I had been warned that my mic was giving feedback, so I didn't realize I didn't unmute it. So once again, good morning all students of Eugene DePuch Law School, and welcome to day 2 of Orientation Week for 2020-2021. As we said, a whole new world. That is what we're going to experience as we go forward. And today the principal is going to introduce the president of the Industrial Tribunal, who is our featured speaker for Orientation Week. And I will turn it over to Principal Galanis at this point in time for the introduction.
Good morning, everybody. It really is my pleasure to introduce the president of the Bahamas Industrial Tribunal, Mrs. Indira Demerit Francis. I've known Mrs. Francis for many years. I saw a sign yesterday that said, you're older than dirt. So we're not quite as old as dirt, but for the amount of years that I've known it, it feels almost like that. Mrs. Demerit Francis is a graduate of the Council of Legal Education. She attended Norman Manley Law School and graduated from there in 1993. That year, she was admitted to the bars of Jamaica and the Bahamas, and began her legal career in the Office of the Attorney General, where she practiced civil litigation. She spent a couple of years there before she went into the private practice at Lebowski and Lebowski, and really developed a specialty in labor relations, or certainly a keen interest and knowledge of that area of the law. Before she moved to the judiciary, she was the assistant registrar in the Supreme Court in 1999, and she was responsible then for the probate registry. I remember those days, and I remember her tireless work in clearing the probate backlog, and as a result of that, receiving commendation for so doing. From that post, she went to the Court of Appeal. She was registrar at the Court of Appeal and served there from 2002 to 2014, quite a period of years. As a result of Mrs. Demerit Francis's effort, the Privy Council, for the first time, sat outside of the United Kingdom, sat in the Bahamas. Their visits, they had a fair amount of visits here, which were at the time really groundbreaking. At the Court of Appeal, one of her notable efforts, or notable achievements actually, was establishing a digital case management system for the court and implementing new rules to facilitate the computerization process in the court. In 2014, she was taken from the Court of Appeal there and elevated, I suppose, it is an elevation to becoming vice president of the Industrial Tribunal. And in 2015, she was appointed as the first woman president of the Industrial Tribunal. Yesterday, the chairman used an adjective, indefatigable, and that is what I would say. That what I would say is an appropriate description of Mrs. Francis Demerit Francis. At the tribunal, Mrs. Demerit Francis has really modernized its processes, and she has disposed of the backlog. I am sure she will say more about that in her speech, but just to say that the implementation of the e-filing platform and case management solution has really been a great achievement again of hers. Apart from her these laudable activities in the law, she is also a community-minded person. She sat on many community organizations. She's an accredited mediator. She's a member of CARB. Was a member of the Bahamas Anti-Doping Commission. And she is a ballroom dancer. So without further ado, I will turn it over to Mrs. Demerit Francis, and so that we can continue with this morning's proceedings. Mrs. Demerit Francis, thank you so much for accepting our invitation. Welcome. I think you might be muted, Mrs. Francis.
Good morning, Principal Galanis. Can you hear me now?
Yes, thank you. Good morning.
Excellent. I'm very happy to be with you this morning and to have been asked to speak on the topic of technological evolution in the practice of law. Is the court a service or building? I thank you for your introduction. I didn't recognize the person you were speaking about, but I thank you for reminding me of some of those things that I may have done in the past. I want to say welcome, students, to your 2020 orientation. Certainly, this is new for me to speak to students through this mechanism, but also I'm very pleased to do so based on the achievements of the Industrial Tribunal to date, which I'm going to talk to you a little about. The question that the orientation puts to you is whether the court is a service or a building. And so I want to say to you right off the top that the court is definitely a service. Now, although we have our residence in a building, we need to understand why it is that the courts are here to serve the people of the Commonwealth of the Bahamas. And so I'm going to make my presentation to you this morning on this topic, and I will ask that I hope you find it interesting, quite honestly. I found this scripture as I was preparing for this presentation, and it says, I wisdom dwell with prudence and find out knowledge of witty inventions. I was very happy to see it because that's what I'm trying to do here in the tribunal. I'm trying to find out about technological advancements that can help the work of the tribunal so that we can expeditiously dispose of cases within the tribunal. Now, before we get started, I think it's important, many of you may know and many of you may not know what the tribunal is or what it's about. So just to bring you, or to tell you a little about my job, as Ms. Galanis said, I'm the president of the Industrial Tribunal. We have 4 courts, which means we have 4 judges, and our specialty is labor law, and we're here to deal with the disputes, employment disputes, and labor disputes. The tribunal was established in 1996 by the Industrial Relations Amendments Act, and the intention of Parliament at that time was to, 1, reduce the cost of proceedings, 2, make the tribunal easily accessible, 3, reduce the formalities, and 4, to bring a level of expertise from the field of labor. Now, the reason that was so important then and even more important now was to bring about the speedy disposal of cases. So the Industrial Tribunal Act is the act that governs the work of this court, and it provides a specific dispute settlement procedure. And if you're interested, because I'm not going to go into too much details about the work of the tribunal, but I'm just trying to connect where I'm going to go, so you can look at Part 5 of the Act, and it's sections 68 through 73 that tells you about that procedure. But briefly, what happens is if somebody is let go or fired from their job and they wish to bring a claim on action against their employers, they have to first go down to the Department of Labor, and down there they have to file a trade dispute. And once that trade dispute is filed at the Ministry of Labor, they then have to go through a process which is outlined in section 68 to 73, where they go to conciliation to try and have the matter settled. And only if that matter is not settled is that matter, or can that matter be referred to the Industrial Tribunal. And so if the matter is not referred, then the tribunal never has jurisdiction to deal with that particular dispute. So I think one of the important things I just want to drive home here with the students now, if you intend to practice labor law, if you intend to practice in these courts, is that every dispute that comes to this court has to come via a trade dispute that is referred by the minister. And what we get is a certificate of referral. And it's literally a certificate that says, I, the minister, certify that this dispute is referred to the tribunal. Now, the tribunal, that section is actually wrong. It's section 66. But the tribunal has the power to regulate its own practices and procedures for hearing of a dispute. And so this particular power, and in exercise of this power, I've taken it upon myself as president to make some adjustments to how we operate in the present environment with the use of technology. And so with the use of technology, I have had, well, certainly from June 2015, a plan that has been mapped out to move slowly towards our goal to bring us where we are today. And so in June 2015, to strengthen due process and the rule of law, we introduced administrative systems required to enhance the performance of the industrial relations judge and to dispose of cases within a reasonable time. And then in June 2017, to improve transparency and public confidence, we created an environment to make justice easily accessible by establishing a user-friendly website to assist with the present administrative challenges, maintain and increase confidence, and promote a culture of transparency. In August of 2019, to promote good relations between parties, which is very, very important, we developed the electronic system for the public to access matters referred by the Department of Labor to the Industrial Tribunal. And then again, in the same month, we also improved security, efficiency, and cost effectiveness by implementing the Folio e-filing system by Apex for the litigants and advocates to securely submit their documents electronically to the Industrial Tribunal. So that's an overview of what we have achieved from 2015 to 2019. And now I'm going to go into a little more detail so that you can get a full view of how technology has advanced the Industrial Tribunal. We have in the Bahamas, and I'm told, certainly the first Industrial Tribunal smart court in the region, and of course, the first smart court in the Bahamas. And I have been asked, isn't it just Zoom? And I'm like, no, it's not just Zoom. We actually, what makes up the components of a smart court is the fact that you have we have a digitized case management solution, a digitized e-filing platform. We have our website. We conduct our hearings by virtual adjudication hearings. We have an automated transcription module. We do have a mobile app. And we're hoping to bring on, in short order, some kiosks to which I'll explain a little later, I think, in a little more detail what they're going to be used for. But our smart court consists of all of these technological advancements, which allows us here at the tribunal to operate all of our services online. And that is why we are a smart court. Our website can be found at www.industrialtribunal.org. We went live, as I told you, in 2017. And the thing about this website, and I think the students should find it very, very interesting because it'll help you if you come to practice here. We have all our procedures online, so you can find out what you need to do before you get here. All of the court calendars are online, so you can click into any judge to find out which courtroom the case is in, where you need to be, and who's hearing the matter. All judgments after the cases are uploaded immediately. If you have a certificate of referral that is referred from the Department of Labor, you can check to see if the case is still open or whether it is closed. All our forms for practice are also online. The practice direction that relates to the VHA hearing, which is our virtual adjudication hearings, can be found there. And also, more importantly, there is a direct link to our eFolio portal that allows you to go into the e-filing platform if you are practicing and you wish to upload documents. Who is APEX? It's important, I think, that, well, certainly in our region, that we give kudos to those who help us to get where we are. APEX is the team that we became partners with at the tribunal to help us advance our technological improvements. And I've been advised also by the principal of the law school that they also have partnered with APEX for other reasons to advance the law school in their technological, I guess, dream to come, or dream that they're in. But in any event, APEX is a nonprofit company. It's Caribbean-based, and they have been established to promote and advance the standards of excellence across the justice sector in the Caribbean community, including court and judicial administration and justice processes. And they do this through innovative technology-enabled solutions, and they are tailored to the needs of the region's justice sector. What does APEX do? APEX serves the Caribbean and supports the coordination, sustainable modernization, and strengthening of the region's justice sector by, one, developing innovative software systems and technologically enabled tools, advising stakeholders on appropriate technology and process solutions, promoting modernization of court systems and processes, procuring relevant technology on behalf of member states, providing training in the use of technology solutions, collaborating with members to share technical insights and international best practices in justice administration and automation, and encouraging and supporting development of local and regional capacity to support its solutions and methodologies. At the tribunal, before we could have even dreamt about computerizing the operations of the tribunal, we faced many challenges. And so I just want to explain some of the challenges to you, because it's important that you appreciate why we felt the need to make these adjustments to the way we now confront the work and get the work done. So one of the first things was that the originating application, which is the document that actually starts the matter here in the tribunal once the matter is referred by the Ministry of Labor, the applicant is required to file an originating application which will outline the claim of the application. And we found that most of these applications were not being filed within the mandatory time, which is 1 month from the time that the person would have been let go or fired. And so really, if it hadn't been filed within the time frame, it shouldn't have come here in the first place. Then we had matters that were being filed simultaneously in more than one court. You'd have an application filed in the magistrate court and the tribunal, or even in the Supreme Court, the magistrate's court, and the tribunal at the same time. So if a matter was heard in the magistrate court and completed, the tribunal would have no knowledge that the case was in fact disposed of, or vice versa. Then we had files that were misplaced generally, and the need for archiving of old closed files so that we knew that the file was in fact determined and finished and ought not to be in the system. We had settlement agreements that were made without our knowledge, where you have two attorneys that may have decided, yes, they filed the matters in the court, but they went about and had it settled among themselves and made no, gave us no notice that the file was in fact finished and closed. So in the system here, it would appear that the file was still open. We also had instances where the applicant and respondents left the jurisdiction and without us being aware that the lawsuit against them just couldn't go anywhere, and nobody knew how to find them, serve them with court documents. And so again, it appeared as though that file was open. We had a lot of situations where the applicant respondent died. And so after filing an originating application in industrial tribunal, and again, the tribunal had no knowledge of these types of matters. And so other challenges would have been files just generally being not kept properly by the registry staff, judgments that would have proved that the file was in fact closed, never met the file, therefore that file would appear undetermined. And also we have an issue with the matters where we have applicants and respondents from the outer islands getting documents to them and getting them here to court to deal with closing of their files. So what we had to do was we had to actually make preparation for the case management system. And our case management system was a part of the Courier suite, which we were able to get from the Apex team, which I explained was the Caribbean-based company that helped us to implement this Courier suite within the tribunal. So the first part of the Courier suite was the Attache, which is the name of our case management solution. And so we undertook an assessment first of the registry in preparing for the implementation of the case management solution. And so we had to do an inventory of both New Providence and of the Northern region, because we have a court in Grand Bahama that is responsible for the Northern region. And this inventory was from the year 1996 up to the present day. So we tried to get a real picture of what we were faced with in terms of our files. So basically I had the judges, we divided the files, and I had the judges read all of the files from 96 to now to determine what was the status of each file, and also identifying the root causes of the backlog and the corrective action that we needed to take by implementation of administrative systems to mitigate these delays. So we call this our cleanup exercise, this inventory, because really it called for us to, roll up our sleeves, to get into that registry, to do a lot of dirt work in order to determine what we were facing. And so we then had to put in the administrative system, which included implementing a systematic call over of case files in 215. And to be honest, this call over case system continues every day here at the tribunal now, because you always find that more cases are filed in the tribunal than we're able to determine at this. The rate of filing is higher than the rate of determination. And so we're constantly calling over matters that we find, like I noted in my challenges, where originating applications may not have been filed by applicants, or we just need to find out what is the status of the case because counsel and attorney have not done anything on the file for a long time, or they promised to negotiate and the settlement has not been brought to our attention. So we do these callovers to ensure that the files are properly closed or in fact need to be determined by a judge in a court. We also developed a case management directions hearing in 216, and this is something that is continually ongoing. This is an administrative tool used to progress matters closer to a hearing or settlement. So if you practice here, you can expect that when you get here, the first thing you'll find out is you'll go through a case management directions hearing. And even in that hearing, there is a section 60 that allows the judge of the tribunal to encourage settlement. And so it is in that hearing that we try to get all of the cases, get to the bottom of what the claim is. Do you really want to go ahead with this claim? Is there any room for settlement? Is there any room for discussion? And we will then allow you to, rest in our conference rooms and try to settle the case as a part of the case management direction hearings. So I gave you a little idea of our preparatory work for the implementation of the Courier Suite, and the considerable work was undertaken by the tribunal, and we had the support of the Apex team. And this is what allowed the accelerated and successful implementation of the case management suite. People always ask, how long did it take? It actually took 2 weeks, but I put under a month because I know some people may not believe it, but in any event, it was exactly 2 weeks that it took us to implement our case management solution. And this was only because the Industrial Tribunal was in a state of readiness for computerization and technological advancement. And because the Apex team understood our local requirements and also brought a wider regional and international perspective to our implementation process. So if I said I had this problem, it wasn't something that they had just heard of. They'd already faced it, and they already had a tool that could help assist me with making things done more easily here in the Bahamas. And the collaboration also included the necessary support services for non-technical staff. So what is Attaché? Attaché is the name of our case management tool. It allows court officers to manage all aspects of the life cycle of a case as it moves through the courts. What are the benefits of Attaché? The benefits and functions of Attaché to the Industrial Tribunal include, but are not limited to, the following: case adjudication, document processing and certification, calendar and scheduling, automated workflows, security and administration, audit logs. These were the steps that I want to note to say how we implemented our first case management software. So we had to configure the Attaché for the Industrial Tribunal workflows and procedures. Then we had to manually enter all of the data for New Providence and the Northern Region. And then we literally had to scan and upload all of the documents for every file in the tribunal for New Providence and Northern Region to our system. And then we had to train the judges of the tribunal on how to use the case management software. And then we had to cross-train our registry staff in New Providence and in the Northern Region. We then started hosting training sessions for attorneys and legal representatives who appeared regularly in the tribunal, both in New Providence and Northern Region. We also staged special training for administrators in both of those regions. What is Folio? Okay, so I talked about our case management solution as a part of our Smart Court, and now I'm going to talk about Folio. Folio is the platform we use for our e-filing service, and this delivers a secure electronic filing via a special web and mobile accessible portal for attorneys, self-represented litigants, and government agencies. The benefits and functions of Folio: it's easy to use. You can use it anywhere, anytime. You have a secure document upload, intuitive user experience, mobile and web-friendly tools, custom notification, and we have transparent document audit trail. This here is what you need to know about if you're going to practice at the tribunal. The registering of attorneys and legal representatives. All users of our e-filing service must first complete a simple registration process. You have to have proof of identity, a valid email address, a valid mobile phone number, which is now a requirement, a valid address, and a new users are required to register as an individual and not as an organization or a company. So the ID belongs to you. So after a user has submitted the necessary documentation to the tribunal to be considered for approval, which the approval is granted by me, what you do is you refer to the e-filing link on the website, which I told you about. There's just, if you go directly to our website at the bottom, there is a link directly to our e-filing portal. Or you can go directly to, as you can see, www.courier.net and proceed to register there as a new user. And when you get there, you're going to fill out the required information and submit it to the tribunal. And then you'll get an automated email, which will be sent to the registering party, whereby he must confirm their email address. So this is what the e-filing portal will look like. And if you see in the red, it says register as a new user. So you're going to register as a new user. And then this is the information that you have to fill out. So all of the stars that are in red, that's a must. If you don't fill them in, then the document cannot be submitted. So once that registration process is completed by the attorney or the legal representative, I don't know if you're familiar with a legal representative, but we have labor advocates that are able to practice by the laws of the Commonwealth of the Bahamas in the industrial tribunal. So you may come here and find out that you're not necessarily going against another attorney, but you're going against a legal representative. What happens is once you have access to your e-filing ID registration, you're then able to view cases. And so you can see the case type, the case subtype, the parties, the judge who's assigned to that case, the type of hearing, and a bit more information, which I'll show you in a minute. You can submit on this portal, I told you already, your documents at home at night, at lunch, wherever you are from another country. It doesn't matter where you physically are. It only matters that you upload and submit your documents. You can review the documents that you filed on the e-portal, which we will show you, and you can communicate securely with registry staff through our portal. It has a built-in message center. So if you want to say something to us about what you filed, you can message us through the message center. You can only see the cases to which you have been assigned by the registry as a party. So people always say, well, can I see anybody else's case? No, you cannot. You can only see your cases once the registry has been satisfied that you are in fact the attorney assigned to that case. When you are no longer that attorney, you will be removed. Next. So let's assume after your documents have been successfully uploaded, we need to make it known that at no point can you delete any documents arbitrarily from the e-filing portal. Once filed, the document becomes the official court record. So if you have uploaded the wrong document, you would need to write into the court and make a request for whatever the adjustment is you may need. How do you upload a document? You just go to the upload document icon. You search for your particular case number of the file to which you have been registered as a party to, and from your browser, you will add your document that you wish to file, and you will select from our e-filing portal the type of document it is, which it'll be showed to you in the drop-down menu box, and then you just press submit. So this is what you would see once you're registered and you are a party to the case. You will note there is the case number at the top left-hand corner. The case type tells you it's a non-essential services. The case subtype is there also, and this would be the limited amount of information that you would see on that case. And then you see right below it, it says upload new document. So you'll click on that. Once you click on that, then you see another face that shows you the case number again, and then it'll say add files. Once you click on add files, there should be a drop-down menu which will tell you what type of file, well, what type of document you wish to add to the system. And so you have the adjournment letters, the affidavits, the applicant submissions, but we are going to choose originating application. So you're going to upload your application, and there it is. It'll show you that the Form A originating application document type, the status is that it's been submitted, and then you see the icons to the right, and it shows you that you can view your document. So we're going to view this document. And there is the originating application. So you're able to view your document. That is the document I indicated at the very beginning that will start a matter within the tribunal once it's been referred from the Ministry of Labor. So when documents have been properly submitted by users, they will receive an automated message confirming which documents were uploaded, a notification of receipt by the Industrial Tribunal Registry, and a notification when the documents are filed by the registry. Now, there's two things I want to note. That documents have to still follow the correct form that is provided in the rules of the tribunal. Yes, you may have access to upload anything, but anything that is considered outside of the rules will not be filed in the tribunal. And just because you've added a document doesn't mean that the court or the registry accepts it as a record or a document that we will accept, because if it's not in the form, it will be rejected. An accepted document would be filed. The question is, how do you know that it's filed? You'd know that it's filed because it'll have the e-filing date. It'll also have the Bahamas Industrial Tribunal seal on it, a pagination, and the case number. And that is when it's an authentic document or record of the court. Now, the benefits for the tribunal judges using this system include the fact that I am able to view all documents filed without having the physical file. So I could do this at home. I could do it in my car. I could do it wherever I am. I can also add notes to the file if I think of something that I want to mention to counsel in the morning. I can add a note so when I go into the system, the note is there and I say, oh, well, I won't forget that. I can also upload my orders and decisions once I've made a determination in the matter. I can automatically scan and upload myself to the case management software. And I can utilize the software on my iPad or my phone, either one. And I can view my calendar from home or anywhere. I can send registry staff tasks or instructions before I get to work. And I can send a message through to other registered users or the staff. This is a little video. Sorry. Okay, I'm hearing you. I hope you enjoyed my little video just to tell you how great hope feels, because you're going to feel that good too, knowing that you could practice the same way that Hope's practicing now. And so my conclusion would be that the technology being utilized is within the constitutional mandate of the Industrial Tribunal to ensure that there is a fair hearing within a reasonable time, because all these things help me to get things done faster, which means that we can give court dates faster. In addition, the added benefits include, but are not limited to, fulfilling the Industrial Tribunal's mandate, reducing operation costs of the tribunal and applicants and the respondents, improving efficiency of case management, improving access to justice for applicants and respondents within the jurisdiction, promoting the rule of law, and achieving parts of the United Nations Sustainable Development Goals with respect to the environment and access to justice. And ladies and gentlemen, that would be my short presentation on the technological evolution in the practice of law. In the court, is the court a service or building? It is a service, ladies and gentlemen, and I thank you for this opportunity. God bless and enjoy your day.
Principal, over to you.
I thought you were hosting. Mrs. Francis, are you willing to take some questions?
Certainly.
So the floor is open.
Good morning, Mrs. Demerit Francis.
Hi.
My name is Betty Wilson. I do have two questions for you. Certainly commendable for the journey the Industrial Tribunal Court has made. But against that, can you say what has been the improvement in timelines in the processing of cases? That's one. And two, can you also say, I guess with the impending, what we see as impending influx of cases maybe coming in from the Industrial Tribunal, how is the court prepared for that possible influx of handling so that there is not a long time in getting to the cases?
Well, firstly, that's why we have most of the technological advancement. As I explained in my presentation, everything becomes, the time to do any job becomes less. Information becomes available to the public more quickly. Questions can be answered more quickly. Therefore, the preparation time for applicant or respondent's attorney or representative becomes easier. There are things that they just don't have to come to the court for. The timeline between filing and adjudication could be anywhere up to 6 to 9 months at the time. And so it has reduced that time frame. And as for the influx, I would say to you, as of to date, we've received 82 applications for this year. And the reason I know this is because I can press a button and find out how many cases were filed up to this morning. So that's how it's impacted the work of the court and the time frame between filing and disposition.
Thank you.
You're welcome. Any more questions?
Hi, good morning, William McFord. Mr. Merritt, do you feel this system would be useful to other court systems like the magistrate court and help with like backlogs of cases that we have today?
I think, well, I don't want to say this system because every system has to be tailored to the rules and regulations of a court and the type of work that happens in that court. And I mean, just to say to you generally, all courts need the assistance of technological advancement in this day and time, because it's just an impossible task to follow the work of any court manually in order to move with times and to do it in an efficient manner and a timely basis.
Thank you.
You're welcome.
Good morning, Ms. Merritt Francis. I have a question of another nature with respect to your judgments, and you can correct me if I'm wrong. By the way, my name is Frank Saunders. Judgments are not, you cannot enforce your judgments. Is anything being done to correct that or advance that?
I'm not sure that's a question for me. That sounds like a question for the politicians. And so I would say to you quite briefly on that, the fact is the law as it stands today does not allow us to enforce our judgments. They need to be enforced in the Supreme Court. And until the politicians or the the competent authority determines that they want to do otherwise, I wish not to comment on that, quite frankly.
Okay, thank you.
You're welcome. Any more questions? I can see, but I can't. So everybody understood everything about the computerization? Very quiet. Come on, I know
I
you.
find that, sorry. Hi, good morning all. My name is Yolanda Hilton. I found that the presentation was certainly very, very impressive. I was not aware that we had such, I guess, technology already in practice, and it was definitely, I guess, again, impressive to recognize that the tribunal was in a state of readiness for such times as we are currently in now. That being said, I'm really interested and anxious to learn and know more about how those things are they progress as we go forward.
Well, I think the law school is planning maybe a day trip to the court, so you'll be able to see the VHA hearings, hopefully in play, and also learn a little more about what's happening. But like I said, there's a practice direction that is on the website. If you have any interest, you may want to read that before you get here so that you are able to see how the hearings are actually guided at the moment, because we have to now make amendments to the law to accommodate and facilitate the technological advancements that we have here at the tribunal. But it is, in fact, the way we're operating every day, and it is what you should expect as young counsel and attorney coming into the courts. So you would need to know, if you intend to practice here, that this is how we are moving forward with dealing with cases in the tribunal.
Thank you.
Good morning, Mrs. Merritt Francis. Thank you very much for your presentation. I'm very much impressed. Years ago, when I acted as when I performed as a human resources manager, I appeared before the tribunal on a number of cases. And so I'm quite impressed to see where we were way back then to where we are now. And it makes me very, very much interested in looking at that part of the law.
Well, that's good, because we need more interested in this part of the law. And there are a lot of cases. I mean, I would say for the year 2018, we probably got 188 applications, 219, 190 some. To date, like I said to you, we have 82. So there's a lot of work out there to be done. And the more people that practice, the better it is. We improve our jurisprudence, and certainly the way we move forward can still be improved. I indicated to you that we hope soon to have the kiosks in the registry. The purposes for the kiosks would be to help those persons who may not be able to afford internet or laptops from homes. And so if they still want to upload their documents, they'll be able to come into the registry and gain assistance and have their documents uploaded from here. We're also hoping to serve people via their mobile phones, because we know one thing, that everybody has a phone. And this archaic way of sending out the bailiff with a piece of paper to rap on your door to find you is certainly not going to work for the future. So there are many, many advantages of this technological advancement. And also I get notifications when I'm to be in court, so I don't forget. It just makes life easier. I mean, I run to court. I still do the VH hearings from my courtroom itself. I don't have to. I can do them from home. I could have done this lecture from home, but of course I'm sitting in the courtroom because that's my preference. But it allows me to be in London and to still host court. So I am happy that I am not just stuck in one place to do my job, but that I can do it from anywhere. And I don't necessarily have to be late, because you don't have to know where I am, but I can be on the screen and I can be offering that service online.
Thank you very much.
Good morning, Madam President. My name is John Fowler. I think I may be piggybacking off an earlier question, but I want to ask it again. Do you anticipate, and this goes to planning, that perhaps given one of the negative impact of COVID has been a lot of downsizing of some companies and even closures, that it's possible that you may see matters being filed to your court, perhaps in greater numbers than the past, matters pertaining to, I don't know, unfair terminations, I imagine, or what's deemed from the former employee's perspective. Do you think there'll be an uptick? Thank you.
Well, I have been told to expect a lot of cases coming forward to the tribunal, which actually, it even makes me more happy to be in this state to accept those cases, because if it is a lot one time, as I noted, it would be very difficult to track manually. And so the fact that we're able to put this information right into our case management solution and track the cycle of each one of those cases, or at least determine whether they require a hearing or maybe just a case management directions hearing, it just becomes easier for me to manage, because we actually get rid of a lot of matters through our case management hearing. They don't actually get to a full hearing because we find out through this process that it's not necessary. So yes, I expect, but I hope not too many. And yes, if we do, we'll be able to manage it because of the technological advancements that we have to date in the tribunal.
Thanks very much.
You're welcome.
Good morning, Mr. Merritt Francis. Davon Rule here. I know that you mentioned earlier that we need more persons practicing labor law. So my question to you is, what do you think stops persons from practicing labor law, and what advice or what suggestion or encouragement would you give to us as students as to why we should practice labor law?
Well, I think, well, I'll be honest. I'm trying to think how honest to be. Well,
be completely honest.
Well, if you knew where the tribunal came from originally, down on Thompson Boulevard, the premises were awful. I mean, I'm not sure that I would have even, I was a labor lawyer practicing down at Thompson Boulevard, and the environment itself, physical environment, meaning there were no bathrooms, it was near alcohol, it was near, what do you call it, a bar or whatever. It was just not a nice place to attend as an upcoming lawyer. So I think just the physical building itself was just something that didn't make you feel good about practicing law. The law itself is exciting. I think what should encourage new lawyers is the fact that we have this technological advancement and the way that I think most of you may operate in your normal lives generally now, especially since COVID. I went to Cafe Matisse 3 days ago to have lunch, and because of COVID, the maitre d' said, I was waiting on the menu, and I said, can I have a menu? He said, you'd have to go on your phone. I said, excuse me? He said, you'd have to go on your phone. We don't give out menus anymore. I said, I got to go on my phone for the menu? And he said, yes, just go to, and he gave me, and I said, wow, this thing's really, I mean, the courts, you think the courts could be behind if I got to get a menu to eat my lunch via my phone? So I say to you, it's just the way things are going to be now. So I think the more practice, the quicker we get it done, and the earlier we get it started, the better we'll become in the future of just accessing justice quickly and hoping that this causes the termination and disposal of cases as it was intended by Parliament when the tribunal was established in 1996. So just what's the word I want to use? Following our mandate is important, and this has allowed us to do so. And we have the power by virtue of the rules to do it this way. And now we just need to make sure that it is tightened in the law to ensure that it is legally being done according to the way we now have our operations set up in the tribunal.
Thank you so much.
Good morning. I just want to say to Ms. Francis, that was a phenomenal presentation, and that I'm quite impressed with the work that you have done to bring the Industrial Tribunal to where it is today. This is Jennifer Isaacs Dotson, and to encourage you that, of course, getting the Industrial Tribunal to be a part of the court system so that your judgments are enforceable, I think it requires the work of the trade union movement to push that. And I know that you have been working with those persons. And so I just want to encourage you that if you've been able to do this work, I'm sure that that also will happen in the future. Thank you.
I appreciate the comments, and I'll leave it at that. So, Ms. Dotson, you want to be a lawyer now?
You see that?
I think that's why she's here.
I thought I didn't recognize you. This lady looks familiar. She does not look like a first-year trainer. Okay. Congratulations on that journey. I'm glad that I could be of assistance in 2 areas of your life.
Thank you.
Any other questions?
Yes, good morning, Madam President. This is Kristen Butler speaking. I just have a question. Considering the global pandemic and all of the advancement in technology that the Industrial Tribunal has implemented, will the courtroom move remotely to virtual hearings and the e-filing system, or will the court revert back to in-person hearings?
Okay, no. The pandemic wasn't the reason that we have all this technological advancement. It only helped us to respond to the pandemic. And so we are always going to have virtual adjudication hearings. And if it happens, we're going to run both in-person court. As you can, I don't know if you can see me, but in my courtroom now, you'll see that we're COVID compliant. So you'll see all the glass surrounding me. And so you'd see that you're able to come to the court to still have your cases heard. But you may find that there is an applicant or respondent who may not wish to be in court in person, but it won't prevent him from being able to get his case heard. So you may find that we have instances where the applicant's in court, but the respondent is using our virtual hearing platform, and we are still able to conduct the case through both methods. So we won't be reverting. This really is the way that the operations of the tribunal will be done, but each case will be something that we'll need to consider what the method of actually conducting that hearing will be, whether it'll be everyone in court, one party in court, one on the platform, or everyone on the platform. It'll just depend on the type of case and what counsel and the legal representatives wish to do in order to make sure. Maybe that somebody's in a foreign country, but it won't stop the case from happening. So no, we will be moving forward as is. Thank you.
Thank you.
Let me make one more comment. When we had Hurricane Dorian, I already had the e-filing and the case management solution in. And so I know the pandemic, it just accelerated what some of the other modules that I put in place, but we were always here operating like this, but the pandemic just caused an increased acceleration of everything that I had hoped to have in place, simply because we were not able to come to work. And I had to then make sure that the work was done. So the pandemic has encouraged everybody who has matters in here to be on board, to be vested in the technological improvements, and to not be afraid to use it, because lots of people, although it was here, they were refusing to use it. Some people are still refusing simply because they don't feel confident or comfortable. And there are times when even I get a little nervous, because this is my first lecture via this method. And so, I don't know, I felt a little, I was like, I can't see them. I don't know who I'm talking to. And I had that level of nervousness this morning. And had I known Ms. Dotson was in my background, I might have gotten more nervous. But I'm saying that only to say that there are things that we have to overcome in order to make people confident, comfortable, to understand that justice is still being delivered, and that it is being delivered fairly even through this mechanism, despite whatever personal concerns persons may have. And so all I could say is it's going to be me continually training persons like yourselves who will, hopefully in the future, may have to come here, and also just training generally, because the other part of this is my staff. My staff, an integral part of the processes here at the tribunal. I can't manage all of the equipment in the 4 courts myself. And so every day now, the way we do things, we're meeting to make sure we're on top of the audits, because when you have technological advancements like this, especially for tracking the life cycle of a case, you then have to make sure that you're constantly auditing the manual file against the digital file. And so for me to be comfortable to go in court without the manual file, I have to be more on top of my staff, ensuring that they know that every document that is filed manually, because I haven't stopped manual filings. I'm encouraging e-filing, but I haven't yet stopped manual filing. So we have 2 things happening at the same time. More persons have been filing by way of e-filing. They don't want to come here because of COVID. They don't want to interact with the staff. And so that works well for the Industrial Tribunal now, because they're learning that they have to take the chance on the e-filing platform. And so I'm going to encourage you, you have to register to practice here.
Thank you. I'm sure some of you may have other questions, but we have to end the session now. As Mr. Guy indicated, or was it Mrs. Francis? There will be opportunity for both years, year one through the court attendance program and year two through the legal aid, your legal aid sessions to attend the industrial tribunal in order to see firsthand what the technology looks like. And if we're lucky, maybe we'll be able to see a little bit of a hearing. So thank you so much, Mrs. Francis. And I think, Mr. Guy, you said somebody, Shanika, I think you were going to
Shanika Carey, Principal.
Yes, okay.
Mrs. Francis.
Hi.
On behalf of the staff and students of the Eugene the Future Law School, we want to express our gratitude to you for taking the time to present to us this morning. The information was impressive, and we just want to say congratulations on all the improvements that you've made in the tribunal. It is also useful information for all of us, not just those of us who want to practice labor law, but as we anticipate that we will be moving forward in this manner in the entire court system shortly. So thank you so much for presenting in such a simple and succinct way, and we assure you that we will take the information and use it in the best way possible. Thank you.
Thank you very much, Shanika. Thank you very much, of course, President of the Industrial Tribunal, Mrs. Indira Demerit Francis. One of the things I wanted students to understand is that this is not only happening in Nassau, this is also happening in the courts in Freeport. And I know we have students who are based on Grand Bahama in the class, so that when we do the visit in Nassau, it will likewise be synchronized with Freeport. So you all will actually get an opportunity to see how these trials can work in on this virtual platform. It's going to be quite exciting to have that connection through the industrial court. So thanks very much again, Madam President. Thank you, Shanika, Madam Principal.